The spirit behind this thing. In legal terms, you don't just read the letter, you also read the spirit. These guys, especially those that failed in the last parliament, are desperate to leave the House having made some kind of note. They are not just wanting to go away. They would rather leave rubbish or stuff with us to take care in the next parliament. I think the outgoing parliament is desperate to pass some sensitive pieces of legislative notices before they leave. This desperacy is amazing. You notice that in our own document we said the bill is being fast-tracked. In other words, we see it jumping steps and areas where it should have rested a bit and reconsidered. And so to us it is a concern. And therefore, to answer your question, is the bill necessary? We don't want to say it is not necessary. But under the very guise of making it very necessary, them making it very essential, they have jumped many stages. At that stage, it should die. And that is why in the recommendations, one of the fraternities, our legal fraternities here, there are several, one of them has said they reject the bill in its current form. That rejection is clear. If it is rejected, it either fails or it's up to them to now decide whether to amend or bring it back to us in an amended form or drop the whole thing entirely. But for me, what I see, the spirit behind this thing, in legal terms, you don't just read the letter, you also read the spirit. These guys, especially those that failed in the last parliament, are desperate to leave the House having made some kind of note. They are not just wanting to go away. They would rather leave rubbish or stuff with us to take care in the next parliament. So for us, that's how I see it. I think it is not necessary. Do you feel it being fast-tracked? Yes. Should we amend it or drop it? Either or, but for us, it's not a good law. Anything that takes away because I've traveled to Europe or to China, and I get some little money, and I'm wanting to send it back here, I have to register first as a non-Ugandan while in China, come back to Uganda and receive it as a Ugandan. What a controversy. Why should we? Why should the Ugandan lose their citizenry or citizenship simply because they are receiving money? I thought Ugandans wanted to make as much money as they can, be in good life, live comfortably as anybody can be. For me, that's the biggest issue for me is citizenship. Why would one lose their citizenship? Because they are getting money. What about my grandmother? My mother is 89. If one of my kids, my son, sends her $200 to go to hospital, first of all, my mother has to register as an agent. Are you telling my mother to go to the district place somewhere there and register as an agent to receive her grandson's support for medical expenses in Kitov Hospital? Is this a nation or a joke?
The bill has come at a high speed, and it has caused the public outcry from different sectors. We have not been given enough time to internalize it, and I think the public also is caught unaware, and therefore there is a need for wider consultation about this, And I think civic education in our country is something that really is quite missing out, because issues of maximum importance of this nature would require that, so that we are on board. The protection of a nation is by all of us, not by a specific group of people. And therefore, there is a need of giving the entire public an opportunity, first to understand and internalize, and so that we come up with something that will benefit our nation together. Otherwise, we may not be understanding what the bill is up to. We may not know what are the outcomes of such very well, but we would appreciate if these are explained and we carry out dialogue upon such very important issues. And of course, the protection of our nation is indeed the goal of every Ugandan.
Bino bigenderera kuggyawo okwerwanako mu nkulaakulana, okuyigiriza okubeera munnansi, civic education, n'ebyokulonda, okukugira okulondoola okulondoola enkola y'emirimu mu gavumenti n'ebyenfuna. Kino kijja kuzibikira eddoboozi ery'obulanzi eri abakulembeze b'eddiini. Akatundu akookubiri, etteeka lino lijja kukugira ebitongole eby'enzikiriza ebyannakyewa n'okukola ku byenjigiriza, ebyobulamu, ebyobulimi ate n'ebirala. Okukugira okufuna ssente bye bigendererwa by'etteeka lino. Tewali akkirizibwa kufuna ssente ezisukka obukadde 4 mu myezi 12 nga tafunye lukusa luwandiike kuva wa minisita. Okumenya etteeka lino atanzibwa ekitongole obuwumbi 4, omuntu kinoomu obuwumbi 2, oba asibwa emyaka 2. Jja akolagana n'abagwira oba omuntu afuna ssente okuva ebweru ajja kweyanjulanga eri minisita n'okulaga gye ziva. Ennyanjula eyo bw'eteba ntuufu eriko ebibonerezo ebikakali by'alina okufuna.
Clause 13 of the bill, Parliament has introduced the offence of prohibition of economic sabotage. The RSU observes that this clause may potentially conflict with Article 29 of the 1995 Constitution of Uganda, which provides for public rights including freedom of association and expression. Additionally, this clause risks being misinterpreted by the regulators because it's too broad and ambiguous and may potentially be used by government to curtail ordinary business transactions, freedom of speech, and expression. Generally, in reading of the application of the bill under Clause 2 and its interpretative Clause 1, most of the activities listed as restricted or described as disruptive by the bill are in breach of the Bill of Rights listed under Chapter 4 of the 1995 Constitution. For example, The bill seeks to criminalize the freedom to assemble and to demonstrate together with others peacefully and unarmed, and to petition government against any cause as provided for under Article 29, Section 1, subsection D of the 1995 Constitution. Cripple free political participation and funding of political parties guaranteed under Article 29, Section 1, subsection E of the 1995, among other violations. Under the bill, the Minister of Internal Affairs and the Department of Peace and Security are vested with powers including the power to revoke or deny certificates of registration as agents of foreigners, or even declare a person or an organization an agent of a foreigner without an impartial due process. Furthermore, the inspectors appointed by the minister shall have broad powers to inspect the premises of any agent of a foreigner at any reasonable time and to request any information relevant to the purposes of the Act. The RC observes that the privacy of individuals, religious institutions, and organizations, as provided for under Article 27 of the 1995 Constitution of Uganda, may be potentially abused by these unchecked powers. And yet, there are no proposed sufficient alternative dispute resolution mechanisms proposed in the bill. Furthermore, this legislation conflicts with the existing laws like the Data Protection Act, Anti-Money Laundering Act, and Public Finance Management Act by mandating public disclosure of sensitive data and duplicating offenses with harsher penalties and fewer safeguards. The broad definition of agents of foreigners. The bill defines agents of foreigners to include a person who acts as an agent, representative, employee, or servant of any person who acts in any other capacity at the order, request, or under the direction or control of a foreigner or of a person, or any of those activities directly or indirectly supervised, controlled, financed, or subsidized by a foreigner. A foreigner is also defined as a citizen of Uganda residing in another country. The RSU makes the following observations then. 1. The designation of a non-resident citizen of Uganda as a foreigner is derogatory in nature and in conflicts with the constitutional guarantees for citizenship as provided for in the 1995 Constitution. A Ugandan citizen cannot be categorized as a foreigner. One cannot simultaneously be a citizen and then render the foreigner at will by law. The categorization of Ugandan citizens residing abroad as foreigners will stifle the channeling remittances from labor externalization and limit foreign funding to the detriment of the country's taxable base. Additionally, 3, being deemed or designated as an agent of foreigners by the Minister of Internal Affairs without any due process is derogatory in nature and a gross violation of the rights of citizenship. H. Part 2 of the bill intends to prohibit a wide range of activities under the guise of protecting sovereignty For the example, the bill limits the following: promoting the interests of a foreigner against the interests of Ugandans. That is in clause 5. Exercising government functions specified in the 6th schedule to the Constitution without cabinet approval. That's clause 6. Implementing, hindering, frustrating, or disrupting the implementation of any government policy. It's clause 8. Interfering with electoral processes or interfering with the will and the consent of Ugandans and governance matters. Clause 11. Interfering with the operations of government. Clause 12. And publishing or participating in any act that damages the economic system or viability of the country, constitution, and economic sabotage. The RSCU observes as follows. 1. These restrictions are intended to stifle advocacy, civic and voter education, restrain election monitoring, policy engagements that call for accountability from government, and economic reporting. This also shatters the prophetic role of religious leaders, as they will not be expected to comment on political or governance issues of any kind. 2. The bill will potentially limit investments by the religious faith and non-government organizations in key priority areas, including education, health, agriculture, among others, by requiring a special permission to engage in them. Yet, private institutions like religious institutions are partners of government in the socio-economic transformation of the country.